Yeah. Yeah.
Adjournment request, if any, from item number 1 to 11.
Please, Your Lordship. Lordship, I'd like to mention as the number 1, 2, and 3, Your Lordship. And they be adjourned for today, Your Lordship.
Why?
The leading council, Your Lordship, they have been stuck in the water logging, Your Lordship.
Huh?
Yeah,
Flood
the water-
affected, my lord. Flood affected.
Not affected.
There are many areas which prevent people from coming out of their houses.
So you are not from that area.
I am not. I am here before you. Yeah, surrounding areas already flooded, but some areas are too bad. In fact,
On the next reading day, next week,
have it a little longer, my lord, if you do not mind, because I'm a
only
little-
they have to.
I have
in respect of-
forgotten everything. I have to read.
In item number 1 and 3, in fact, 2, you're supposed to argue, but 1 and 3, I think so, that is due to the subsequent development.
What is it?
What remains in these
Not
matters?
connected.
No.
Because
It must be on the
ultimately their services have been regularized.
Two.
1, 2.
Amar to whom?
It is right. 1.
Oh,
It
one auto call. Oh, I think I am only in one.
Oh, you are in 2, sir.
I'm sorry.
Look, must be on the
One
One
of
on
the
the
respondent.
Eight respondent.
Oh, I
Maybe
see.
in the others
I
also.
see. I am in both 1 and 2.
2 is altogether different, whereas 1 and 3, in fact, they put a condition to appear for appearance in the TET examination.
Oh, that is different.
And later on, now their services have already been regularized.
Regularized. Your lordship has passed an order. that
Order,
day.
and on that day, they said, I'll confirm Mr. Majumdar.
Ah.
So 1 and 3, I don't think so there is anything in this 1
So
and 3.
he is not here, no?
He is not
He is not here. That is the problem.
This 1 and 3, Pradhan Ismail, and request is made on behalf of the council for the state. That
Others kiss puntu.
Mr. R. Majumdar, council for the education department,
Two.
is not able to come today on account of flooding in the area where he is residing. List next list after a week. इसमें कर देना. The writ appeal number item number 2 में अलग से लिख देना. Writ appeal number 238/2016 is detached from writ appeal number 360/2014 and 23/2017.
In do it.
And the request of Mr. PK Gaurav, senior contact assisted by so and so. Place this matter in the month of June. June.
June.
June is a little problematic month, below for me. If your lordships don't mind, we will have it a little later. July.
July. Yes, sir.
Obliged.
Make Your Lord. I pray for adjourning of the matter of item number 11, Your Lord, for today. I submitted the adjournment slip yesterday, Your Lord.
Lordship, I'm appearing for the, my lord, appellant over here, my lord. I'm being led by, I'm for the appellant, my lord. My lord, can it be fixed on 29th, my lord, today, since they have an issue, my lord? There's an urgency in this matter. my lord.
August or September.
My lord,
We are
my lord, that
seeking
will be too,
adjournment,
that will
August
be
or
too long, my lord. My lord, we have given consent, my lord, but can it be on 29th, my lord?
August.
August first week, my lord, please, my lord.
August first week.
August first week.
Much obliged.
Deeply obliged.
May I please your lordship?
This is the learning.
My lord, there's an interim, my lord. There's an interim in this matter.
Adjournment request for adjournment slip was circulated on behalf of the council for the respondent with no objection from the council for the appellant. Place this matter in the first week of August.
Now there's an interim order that may be extended until the next
Order, if any, is extended till next.
of this thing. Deeply obliged.
May I please your lordship? Lordship, with the consent of the other party, I beg to mention item number 4 to kindly pass over for the day, lordship, as my senior is not well.
It will go in that
Lordship, I'm for the respondent number one. Lordship, the hearing, the respondent was terminated from service. So, Lordship, in 2020, Lordship, so,
Stay order is
so,
operating.
Lordship, could the matter be taken up for hearing next week, Lordship?
August.
Lordship,
The request is made on behalf of the council for the appellant for adjourning the matter. The council for the respondent has no objection, list in the August. Yes,
Any other request?
My lord, may I pray, my lord, I will permitted to move a unlisted writ appeal, my lord. The urgent matter, my lord.
send a request to the registry, we'll consider.
My lord, yesterday, my lord, judgment was delivered, my lord, with respect of, my lord, tender matter, my lord.
Sir, you please request the registry, registry will place it before on administrative side, we'll pass a note.
Okay.
Daily list for hearing, item 5 to 8.
These matters are covered, my lord.
Which matter?
Yes. There is a division bench judgment, my lord. Basically, we are saying we couldn't have paid fixed pay, only to that extent. We are entitled to the, my lord, regular scale. Copy answer nahi. 2024 5 GLT 689.
Matlub Khan.
Yes. Manohar Ali Sheikh, my lord. Mohar Ali Sheikh.
More.
Yes.
Who is for the other side?
State, my lord.
Which is the department is education.
Of course, my lord, the state has filed a review petition, notice has been issued. But then, my lord, in respect of this judgment, please come to para 168, my lord, at page 749. और এখন দিয়ক না। Copy আছে নেকি আমার? হ্যাঁ? Oh. May I read it, my lord? If your lordship will straightway come to para 171, 70, being government servant, the tutors would also be subject to all the provisions of the Act, rules, laws that are applicable to an employee of the state government of Assam. Their job would also be to of a teaching job. The only distinction that would be applicable in their case is that tutors will be entitled to a fixed salary as opposed to regular pay scale enjoyed by all other category of teachers, employees serving under the government of Assam. Whether the services of the tutors should have been provincialized or not is a matter which should lie exclusively in the domain of the policy of the state, and this court would not have any opinion to express in that regard. However, once a decision has been taken to provincialize the services of the tutors by following the provisions of the statute, will it be permissible for state to extend a differential treatment to them as compared to other government servants who are enjoying a regular scale of pay, which is normally payable under the law? The answer to the said question has to be in the negative, for such a measure would amount to denial of equal treatment to tutors under the law. It is to be noted herein that services of the teachers and tutors have been provincialized under the same statute and by following the same procedure. The nature of duties and responsibilities are similar, and both the categories of teachers are involved primarily in teaching job. It may be correct to say that due to the difference in their educational qualification, teachers and tutors belong to two different classes and therefore they cannot claim equal pay. However, the question here is not of equal pay for the work done by the two categories of teachers, but of equal treatment and equal protection under the law. What cannot be denied is that by virtue of their acquired status as employees of the state of Assam, the tutors would be entitled to equal treatment under the law as it extended to the other government employees. Therefore, since the other employees are enjoying the benefit of a regular pay scale, whether may be the pay scale extended to them, it will be incumbent upon the government to extend a regular pay scale to the tutors, as also otherwise same would not be only amount to unfair treatment extended to tutors, but may also have a demoralizing effect on them, which in turn may have an adverse impact on the performance of their duties as tutors. So here also, my lord, the same category of persons,
These
one
are-
are getting
These are the
scale.
tutors.
Yes, ma'am. Not tutors, my lord. We are also not teaching staff, but we are being paid fixed salary. In this case, my lord, there was a category of teacher and tutor. Teachers were getting regular scale, tutors were getting fixed pay. Here,
Here it's a non-teaching staff.
non-teaching staff.
They're relying on the division bench judgment.
Lordship, I'm not aware of the case, Your Lordship. I pray for a day accommodations, Your Lordship, because our Muzumdar was leading in the case, Your Lordship.
He is stuck in floods.
Ma-
Next week, लिखिए वो same order कर देना कलेक्ट मिस्टर आत्मा के ऊपर. Next week.
Next thing, my lord.
Applies, Lordship.
Item 9 and 10.
May I please, Lord? In this case, Lordship, Advocate General is supposed to appear in this matter. He is busy in court number 10, Lordship, in a part matter, Lordship. And I'll pass about further day, Lordship.
There is no other matter.
Pass about further day, Lordship. Day after tomorrow, Lordship.
Next week.
My lord, may kindly give a date next week, because I am under suspension for quite some time now, my lord. Next week, any date convenient to your lordship.
3rd of June.
Yes.
3rd of June.
Oblige.
For orders, item 1.
Yes.
My lord, we have received the report, my lord.
May I please, your lordship, my senior Mr. S. Botakur is on legs. Kindly pass over the matter for the time being.
As both Thakur, there is no, as both Thakur review petition has already been dismissed. That was already closed. Mr. Both Thakur has filed a review petition that was already closed. It is only for the purpose of status report in respect of FIR number 220/2020. This is the only.
Much ado.
This is of August 2023.
My lord.
What happened thereafter? Investigation is concluded, whether the charge sheet is filed or the final report, negative final report is filed. What happened?
That instruction we have to take it.
So that instruction today is listed for only this.
My lord, that was, my lord, available, my lord, actually.
So that was available on 30th of August when this court has passed this order. That was very much available. This means nothing. You asked on telephone. What happened to that?
I will.
Which police station FIR is this? Baralumuk police station.
Yes.
Ask him. Phone करके अभी पूछो उसका क्या हुआ? 220/2023. What happened to that FIR?
My report.
Immediately. Phone him.
Item number 2.
This is the review, petition that page number 17 is, page number 16 is order of writ appeal, my lord.
We have already gone through that.
Yes,
Now, what is the ground for review?
ground for review, my lord. In that case, my lord, kindly come to page number 30. paragraph number 32, my lord.
32
Yes, my lord.
of the impugned judgment.
Impugned judgments, yes.
Fine. Yes,
Here, my lord. May I read, my lord?
yeah.
According to the appellant shall be reinstated in service. However, he shall be deemed to be under suspension from today, that is on 7/12/2022, till the fresh order of penalty is passed by the competent authority. As regard earlier period from the date of passing compulsory retirement on 23/5/2015 till today, since the appellant has not rendered any service, even if appellant will be also deemed to be under suspension, there shall not be any question of payment of any allowance of the salary for the period which he had not in. However, all these factors will be considered subject to the final order of the penalty and which will be passed by the disciplinary authority within the period of 2 months, my lord. Here, my lord, honorable division bench, that is in paragraph 31, my lord, under page 29. Under the circumstances, we are of the view that authorities will be required to revisit the decision as regards the quantum of punishment imposed by appellant, and for above reason we are satisfied the appellant is able to make out the case of interference from this court. Accordingly, appeal is allowed by interpreting decision of the learned single judge, and consequently we are also inclined to interpret the order of penalty dated 23/5 as well as the order of affirmation dated 5/8/2015, and the matter is remanded to the disciplinary authority passing a fresh order of the penalty without taking into consideration the past adverse order. That is our ground of review, my lord.
So
And-
why? What is wrong in this?
My lord, against that, we have approached the Supreme Court, my lord. That is, the Supreme Court has remanded back to the, that is page number.
Where is the demand?
Remand is, my lord, page number 128, my lord.
Okay.
So, my lord,
So the court is not allowed.
it is not allowed, but we are
They have simply said, you are at liberty to file a review petition, file a review
a
petition.
review petition. Well, our ground of review is that not taking the past, his past conduct, my lord. That is in disciplinary act, my lord.
The only ground which you have apprised the relevant office memorandum and also the constitution bench judgment which permits consideration of past misconduct for imposing penalty against a delinquent.
Yes, my lord.
So where is that constitution bench judgment? And which is that office memorandum?
Office memorandum is, my lord. Case number, my lord.
Yeah. You sought permission or you sought liberty to file review petition on two grounds.
Yes,
That there is an office memorandum
yes, ma'am.
which permits to take into consideration the past conduct,
Yes, ma'am.
and another is the constitution bench judgment, which as per your this submission
Yes,
seems it is contrary to or it is not affirming the view of the Honorable Supreme Court taken in Umed Bhai case.
yes, ma'am.
Yeah.
Regarding,
So show us first of all the constitution bench judgment and then the office memorandum. Or first show us office memorandum and then constitution bench.
the office memorandum, my lord, that is not in there. Office memorandum regarding the past conduct, my lord.
Obviously, that is the ground.
Yes, ma'am. But Supreme Court constitutional bench, not the constitutional, I have the some judgment of the Supreme Court regarding taking.
Madam, this was your argument. K. Parmeshwaran, learned appearing for the petitioner submitted. The High Court should have been apprised by the relevant office memorandum
Yes,
and also the constitution bench judgment which permits consideration of past misconduct for imposing penalty against a delinquent.
yes. Regarding the office memorandum, I request some time, my lord, for office
No,
memorandum, my lord.
I'm sorry.
Today itself, my lord, after half an hour, only three
No,
cases are there. Only three
there
cases
is
are
no-
there.
Only one matter is there
My lord,
and nothing else. No, ma'am. Yeah, either you show us in the review petition, you have annexed any office memorandum.
No,
Show
my lord.
us. Show us. In the ground of the review petition, you show us one ground that this is the date of the office memorandum,
Yes, ma'am.
which permits. Now we'll read your grounds one by one. Come.
Yes, look.
Page number 7
Yes, ma'am.
and para 6.
Page number 6.
Para 6, page number 7.
Yes,
Read.
yes, ma'am. The review petition begs to submit an honorable division and high judgment on order that demanded the method to the disciplinary authority for passing the phrase order of penalty without taking into consideration the past adverse remarks which are reflected in article of charge 3, charge number 3. And he was he was directed to reinstate the petition in service. The Honorable Supreme Court, while dismissing the SLP, considered the pleading of the review petition and allowed to move in its review jurisdiction. Accordingly, review petitioner has filed this review petition against the judgment and order dated so and so on following ground. Ground A, my lord. For that, on the basis of which this honorable court dispose of the writ appeal seems to be made under some misconception as same is not in accordance with the office memorandum and contrary to the record of the case. The aforesaid order dated 7/12/2020 passed by honorable division deserves to be reviewed on the ground of misconception of the fact as well as for which the review petitioner cannot be made suffer, my lord.
Now come to this ground only. Your argument is that the division has passed the order, impugned order under misconception that
Yes.
the same is not in accordance with the office memorandum. So where is that office
Office
memorandum?
memorandum is, my lord, that is case number.
For which, now come to another ground.
Yes, my lord. Next ground, my lord. For the case, case number 103 is, my lord, that is office order.
103.
103, my lord.
Okay, 103 come.
That is not for earlier misconduct, that is his regarding his undisciplined activity, my lord. Case number 103, my lord.
103.
Yes, my
It
lord.
has been learned that in spite of repeated direction, the personal
Regarding his misconduct.
carrying
That is
their
regarding his
mobile phone,
misconduct,
doing
not
the
on-
duty
yes.
in once directed that he has no personal chat carry. Okay,
Yes, my
that he has flouted that.
yes, my lord.
That is the fact which
Yes, ma'am.
we are also admitting.
Yes,
Office memorandum which allowed to consider the past
past
conduct
misconduct, my
in the
lord.
disciplinary proceedings.
Yes, my lord. That is not there, my lord.
Now that constitution bench judgment, ma'am,
That is, my lord.
this is a constitution bench
Not
judgment.
considered, this is not a constitutional judgment of Supreme Court, not constitutional bench.
That judgment of the Supreme Court, the division bench has also relied on judgment of the Supreme Court, constitution bench judgment.
Yes, my lord.
What is that? 5 judges.
Five judges, this is not five judges judgment. My lord. That is, my lord, 2010 2 SCC, my lord. Here, my lord, they considered, my lord, earlier conduct, my lord.
Madam, earlier conduct, the facts of the case are altogether different.
Yes, my lord.
Earlier conduct, his conduct was not good. But in the year 2010, you granted promotion to her despite those adverse comments. Then again, while initiating disciplinary proceedings, you you relied upon those misconduct,
Yes, my lord.
which was in fact waived or condoned by way of giving her promotion. That is what the division bench has said. That once you have waived those misconduct by way of your conduct, now you can't rely upon those previous misconduct, which has been condoned.
This memorandum is not there,
Office
my lord.
memorandum, there is no office memorandum
Yes.
as such.
Yes, my lord. Yes.
Hey, nahi kuch.
Yes, ma'am.
Take care.
And
This review petition is filed by the review petitioners seeking review of the order dated the judgment dated 7th of December 2022, passed in writ appeal number 22 of the 2021. Full stop. The division bench of this court in writ appeal number 22 of the 2021 has reversed the order passed by the learned single judge in writ petition number 6282 of the 2015, decided reverse the order dated 23/5/2015, passed in writ petition number 6282 of the 2015, and directed and remanded the matter to the disciplinary authority to for passing a fresh order of penalty without taking into consideration the past adverse remarks, which are reflected in the article of charge Roman III. The division bench has also directed that that the non-applicant here filed by the writ appeal 22 filed by the non-applicant, whereby the landed single reverse. The division bench has also issued a direction to the respondents to reinstate the non-applicant slash writ petitioner and treat the period for which he remained under and treat the period of his treat the period wherein he was not in service as suspension, and certain consequential directions have also been issued. Full stop. It appears that the review petitioner has approached the Honorable Supreme Court by way of filing an SLP. The details, SLP ka 120, say details like SLP number so and so. However, they said the SLP, however, on the day of hearing of that SLP on 4/7/2023, and submission was made on behalf of the counsel for the review petitioner that he may be permitted to withdraw the special leave petition SLP and move the High Court in its review jurisdiction. The Honorable Supreme Court has dismissed the SLP as not pressed while granting liberty to the review petitioners to approach this court with in its review jurisdiction. It appears from the order dated 4/7/2023 passed by the Honorable Supreme Court in SLP, the respondent writ petitioners was sought liberty for filing a review on the ground that the High Court has ignored the relevant office memorandum and also the Constitution Bench judgment which permits consideration of past misconduct for imposing penalty against a delinquent in disciplinary proceedings. Stop. We have gone through the grounds of the review petition and has also heard learned counsel for the review petitioners at length. The counsel for the review petitioners have failed to place any office memorandum which permits consideration of past misconduct for imposing penalty against a delinquent in the disciplinary proceedings and has also failed to press into service any judgment of the Constitutional Bench of the Honorable Supreme Court which the Constitutional Bench of the Honorable Supreme Court taking a contrary view as has been taken by the Honorable Supreme Court in State of Gujarat versus Umed Bhai M. Patel, reported in 2013 SCC 314, on which the division bench of this court has placed reliance while passing of the order and the review dated 7th of December 2022. Hence, we don't find any merit in this review petition. The same is there for this one. Yes.
I am saying item
Item one.
My lord, successor notice has been submitted, my lord, because investigation is going on as per instruction, my lord.
Last 2 years.
Because, my lord, due to some problem, because at that time, my lord, Mahendra Mohan Chaudhary Hospital was here. Medical report are not found out. It could not be found out. Because that has been closed.
It will be part of the case diary because so far I recall there was a findings recorded by the magistrate in the case diary itself, that there are injury marks and all.
Yes. You are.
But I am for a review petition, my lord.
That review petition is on.
Yes, my lord, it's become the boomerang for me, my lord.
Okay. This matter comes upon for consideration. Only for the purpose of submission of status report in respect of investigation conducted by the police in the conducted by the which police station?
Orolabuk police.
Huh?
Orolabuk.
Varunalogun police station in FIR number 220/2023. The counsel appearing for the state has informed that investigation into the above referred FIR is still going on. And is still going on. Full stop. Taking into consideration the above fact, we are of the view. We deem it appropriate to close these proceedings. However, it is expected that the investigating agency shall conclude the investigation into the FIR number 2/2023 of so police station expedition.
Obliged. My lord, there is a cross case also, my lord, registered against my lord, Manoj Kumar Upadhyay.
That is the petition, my lord.
We are not concerned about.
Item number 3.
limited prayer, your lordship. Your lordship, there is a confusion because there is a categorical finding by this honorable court that petitioner has entered into service in 2003, your lordship.
Yes, that is there.
Your
Page
lordship,
number, come to page number 16 of the judgment.
is number 16.
Page number 16 of the judgment which we are in clarification. B. New defined pension scheme. In the case in hand, in no ambiguous term, the communication dated so and so, it was made clear that the government, by the government, that the employee will be treated as regular employee of the Panchayat Raj institution. The communication dated so and so. Also, is no ambiguous term discloses 1272 number of posts created with effect from and ex post facto certain of the such was accorded to treat the GP secretaries so and so with effect from so and so. In view of such decision, the government and the resultant ex porto appointment from the communication dated, the communication dated for to automatically loses its prospective discussed here and above. Nothing discernible from the record which secondary realization was necessary for the so and so. Therefore, the writ petitioner cannot be treated as a new entrant of joining government services subsequent to the introduction of the new pension scheme so and so. Then there is a categorical finding that
Your lordship,
they would be deemed to be regular
Yes.
employees from 4 to 2006.
your lordship, he was engaged without any post in year back 93, your lordship. And his service was regularized in 2003 without any post, but ex post facto approval was given for creation of post, your lordship. So 2003, from 2003, he is in government service, your lordship.
Sir, please come to this page 16 of the interim judgment, para B. A conjoint reading of the communication dated so and so, 30th of May 2003 and 4 to 2006 and 28/3/2000 leaves no room of doubt that the posts were created by the state ex post facto with effect from so and so. And therefore, it can safely be concluded that the services of the petitioners is to be treated as an appointment in a substantive post with effect from 10/6/2003.
Yes, yes, we are not disputing this, your
Then-
lordship. So, your lordship, in the conclusion part, your lordship, conclusion part of the judgment, your lordship, at page number 164.
Yeah.
164. In view of the aforesaid discussions and reasons, this court cannot but hold that the offending portion of the order, we are not on that. You understand? Next paragraph. In view of the aforesaid decision, discussion and reason, this court dismissed the present writ will being devoid of any merit and resultantly uphold the impugned decision dated so and so passed by the learned single judge. Your lordship, learned single judge has directed the state to consider his case in the light of the judgment passed in.
But treating is substantive appointment from 1991.
Yes, yes. Your lordship.
This is clarified. It is marginal.
So clarification in the state, your lordship, clarification is
Explain.
whether we will consider him from 2003 because there is categorical finding.
10/6/2003, that is.
Yes,
to be
yes.
considered.
Yes.
Yes, Mr. Vodu.
Well, in this case, well, this entire issue was settled long time back in 2010. Well.
Oh, that's right.
So the
But now
yes, well,
the division bench has already recorded as finding
my bad.
that the appointment in a substantive board with effect from 10/6/2003.
Yes.
So for all purposes, this his appointment, regular appointment is to be treated from 10/6/2003 and not from 1991
No,
or
the
1999.
difficulty, my lord, that the qualifying service, my lord, in terms of the judgment of this on.
That is altogether different.
My lord.
Only clarification is required that the judgment passed by the learned single judge in so and so writ petition
Right.
is not interfered with except the above modification.
True, my lord. But what is happening in reality, my lord, they are, my lord, not qualified, counting that qualifying service, they're reducing the pension, my lord. That is the difficulty that is.
That is a different cause of action.
That is a
Here
separate-
it was something very
But
different.
that is what is happening in
that
reality. my
is
lord.
a separate cause.
That's the only difficulty, rather than the
This-
clarification, my lord.
IA is preferred on behalf of the state with the prayer to state seeking a clarification in the impugned order dated, seeking a clarification in the order dated, order and judgment dated 5/8/2023, passed in writ appeal number 133/2023. Full stop. The learned counsel for the state has submitted that there is a confusion to the effect that whether the services of the non-applicant, writ petitioner are to be treated as regularized from 10/6/2003 or from a earlier day. Stop. We have gone through the judgment dated 5/8/2023, passed in writ petition number 133/2003, and find that in para number in Roman में कर देना 5 और उसका कर देना B. Roman 5B, the court has recorded, the division bench has recorded a specific finding to the effect that the appointment of the non-applicant petitioner is to be treated as an appointment in suspensive post with effect from 10/6/2003. So, in view of the said specific finding, recorded in the judgment, we deem it appropriate to clarify that the services of the non-applicant writ petitioner are deemed to be regularized from 10/6/2003 and not before that. With these clarification, this IA is disposed.
My lord, only para page 15, my lord, of the judgment, my lord.
Yeah.
Here, my lord, it has been clearly stated, my lord, that there will be, my lord, the qualifying service will be from the initial date of appointment. That has been,
Sir, we are simply
Fine.
recording this, otherwise we have not interfered with
Fine.
this order. Whatever relief is flowing from this order, you will get that.
my lord.
Oblige.